Well, Governor J.B. Pritzker denying the option of responding to State Representative Dan Caulkins' filing at the U.S. Supreme Court over his challenge to the state's gun and magazine ban and the questions of conflict of interest that weren't fully resolved. And if you recall, back in what was it, March of this year? Earlier this year, I asked Governor J.B. Pritzker to explain why he gave $1 million to two then Supreme Court Justice candidates, Elizabeth Rochford and Mary O'Brien. He gave $1 million campaign contribution to each. And this is what he had to say in response to that question I posed to him. I'll go ahead and get this pulled up here so that you can hear this as well, but here is Governor J.B. Pritzker from earlier this year.
I am sure this is something that the right wing is trying to stir up. I know you've written about it. The fact of the matter is I supported candidates who are running all across the board. If you're suggesting that the fact that I gave money to, let's say, the Democratic Party or to the committees that supported candidates means that everybody who received any money has to recuse themselves from anything to do with the state of Illinois, that's ridiculous. And I've certainly never asked anybody to vote a certain way or decide on a case a certain way. I would never do that. I never have. I never will. And these are independent judges, and they didn't go around and campaign on things, that they thought would win my support for them. I believe in them. I supported them like lots of other people did.
So again, the governor saying that, to think that somebody should recuse themselves because he gave $1 million to their campaigns, he says that's ridiculous, is the direct quote. He was then asked a week or so later about why he decided to give that money. What was he expecting to get from that $1 million? And here's the governor answering that question.
Well, my hope is that good people get elected to public office. That's why I think you would contribute, or anybody else in this room would contribute to somebody. I would also point out that, unlike what some people are putting forward among the right wing, the truth of the matter is that my name is on these suits because I am an official representative of the state of Illinois. When I became governor, there were suits that were outstanding, and Rauner's name was removed from those suits, and my name was put on them. It had nothing to do with me specifically, just the fact that I happened to be governor at that time and this time. So the conflicts that have been alleged are just, false. And I'm must say that I think people who run for judge do it for the right reasons, and I think that people who give to candidates for judge do it for the right reasons. And judges ultimately are required to make their independent decisions about the cases, and I think that's what judges that any of us support should do, and I hope will do.
So the governor, again, just saying that, hey, he feels that these were the right people for the right job and hoped that they would, do good work as a justice of the U.S. Supreme Court. But the governor being a named defendant in a challenge against Illinois' gun and magazine ban, while giving that sum of money to two then Supreme Court justice candidates, it's obviously a question of a conflict of interest. And somebody who filed in the Illinois Supreme Court to get this addressed and to have these two justices recuse themselves from hearing the gun ban challenge. That request, that motion was denied by those two justices and ultimately by the court. And they ruled against Dan Caulkins, the state representative, and now it's in the U.S. Supreme Court. So joining us now to talk a little bit more about this is Jerry Stocks. And Jerry, it's kind of fascinating because, here we are. We saw that several weeks ago you guys put this into the U.S. Supreme Court and got it docketed. But then we were waiting. I had it on my calendar to see if, what the governor's response would be. I believe that was supposed to be December 14th. Friday, we got a waiver. What exactly happened Friday that people need to know about?
Whenever a petition for writ of certiorari is filed, the respondents will have the opportunity to either waive their right to file a brief, which is what the respondents or defendants here decided to do, or they'll have a deadline to file their response. Often there's a school of thought that if you don't file anything, you may make the issue not look that serious, or at least reduce the spotlight that the petition otherwise may garner. But I think there's something a little different here that informs why they can't respond. They would be in a position with our primary grounds for vacating and voiding the Illinois Supreme Court opinion under what's called the 14th Amendment or Caperton challenge. They have to defend the actions of the two Supreme Court justices that declined to recuse. And if you may remember, they stood silent when it was filed the first time, which partly informs, at least from our cynical view, how much they are perhaps tied cooperatively to the shared political outcome. But it's an indefensible position. And keep in mind what happened just approximately 2 weeks ago. The Illinois State Board of Elections, to my knowledge, confirmed a penalty against one of Senate President Harmon's counsel in the case for $99,500. I think pretty much a record because of concealed independent campaign expenditures from an independent committee for the benefit of Justices Rochford and O'Brien. Now, it was concealed, meaning it wasn't reported timely. And prepare for this: $700,000 of the funding that I'm about to describe came from Harmon into this committee run by his counsel that contributed an additional $7.3 million to elect Justices Rochford and O'Brien. That is in addition to the $2.6 million from the defendants and their counsel that went to their election that we raised in our petition. Those are just the direct expenditures that went directly to the campaign funds of the judges where they could control the messaging. Well, the other 7.3 was non-disclosed, meaning the voters had no opportunity to know those expenditures that came from the committee controlled by Mr. Kaysen, one of the counsel appearing for Senate President Harmon, to the tune of $7.3 million. A lot of the gifting was what we call split reporting, where they're running television ads, a committee called All for Justice. I just learned this. Tomorrow or Tuesday, depending when it gets back from the publisher, we will be filing a supplement to our petition, raising these issues and pointing out this newly discovered material. Let's put this in the context of the Caperton case, which is the 2009 U.S. Supreme Court opinion that was a 5-4 opinion. Ironically, more liberal side of the bench was in the majority versus the more conservative in the minority or in the dissent. But it says there are intolerable limits to the indications or indicia of bias for assuring that there's 14th Amendment due process to a litigant. In Caperton, there was only $1,000 of direct gifting from the litigant to the challenged judge. In Caulkins, there is $2.6 million. A 2,500 to 1 ratio. In Caperton, there was approximately, from two different sources, $3 million of political committee expenditure for the indirect benefit of the candidate. In our case, Caulkins, we have an additional $7.3 million. A lot of it, the same ads attacking the Republican opposition or opponents, one being an incumbent on the Supreme Court for the benefit of Justices Rochford and O'Brien. So in terms of magnitude, this is just the money, all right? And Caperton was just money. We are Caperton by magnitudes on the money, but we have evidence of a shared commitment to a specific outcome with the contributing defendants who are also the leaders of the other branches of government. The significance of that shared commitment. It wasn't just an expression of judicial philosophy. I mean, a judicial candidate, they have free speech rights and campaign rights, and we're not even in that realm. They specifically signed off or allowed themselves to be represented to the public as signing off on a specific outcome of an assault weapons ban. And here, this next phrase is significant: when the General Assembly reconvened. All right. Now, the very first issue in our case, and the issue that drew 2 dissents by the Illinois Supreme Court, is saying that we cannot continue to ignore what we obviously know is taking place, challenge the very process by which this bill achieved presentment to the governor for enactment. And that's the outcome. Not only were they pledging themselves to an assault weapons ban, they were pledging themselves to the process by which it would come to pass and the immediacy by which they expected it to come to pass. And it all played out that way. And then we get to a third level that is absent in Caperton, and that was intolerable. Here we have the leadership of the other branches of government that are the ones contributing these funds, sharing these commitments. And that strikes at the heart and core of the independence of the judiciary, a de facto dissolution of separation of powers under our state constitution. It's an Illinois story. This isn't just a Second Amendment beef. This is an Illinois story, and it tells the story of time and again. We have seen in Illinois how laws gut and replace actions to make laws to permit the political faction in control to oppress the rights of others, and taking the laws that govern the processes that govern their attainment of those ends and disregard it when it's inconvenient. Now, our opinion issued by the Illinois Supreme Court, the majority opinion, is a study of ends-based construction. If there was a principle raised below, they just pretended it wasn't there, so that they did not have to deal with the issue. Now, keep in mind that we won a final judgment in the circuit court, and that final judgment is distinguishable from all other litigation in this case, where we've only been dealing with what's known as an interlocutory order or a temporary and potentially reversed order. We got a final judgment. They sought no stay. Fact of the matter, and we've had this discussion before, it would have had application across the state at that moment.
They argued that that was not the case. They argued that it was just for Caulkins and the other named plaintiffs.
Yeah, and that is, they never argued that in court. They never argued that in any type of judicial relief. They never sought a stay where they would have to actually articulate that argument and have it rejected. They simply stood on the bully pulpit and intimidated the citizens of the state of Illinois into thinking that is the case, because it does not stand a final judgment. And you may see this, you have probably seen that type of discussion in some of the commentary on Beavis, is that, well, it's not a final judgment. They will wax and wane on a legal principle, irrespective of consistency between those two between whatever forum they are communicating in. They don't even strive for consistency. But so they could have sought that adjudication. We won. Caulkins won in the trial court. The judgment is what it is, and it was from early March to August 12, a judgment that was in force and effect. Now, a lot of folks may have acted upon a position consistent with ours. And I don't know, they may have been acquiring some assault weapons, and now they're really in a pickle. Is what do we do now as this endorsement is imminent? But another comment about our Supreme Court opinion. When we won the final judgment below, the principle, an unimpeached principle, really, until this case, is that a successful litigant securing a final judgment in a lower court can rely upon any basis appearing of record to affirm that judgment. And the review in this case is what was called a de novo review, meaning the court can look at anything that took place at the trial court level. But when you read the Illinois Supreme Court opinion, they simply said issues weren't raised when they were briefed, articulated clearly, weren't raised below, or weren't raised sufficiently, or were mentioned in passing. All of that being a false construct so that they could avoid confronting inconvenient issues to the conclusion their benefactors sought them to achieve in the case. The addition of this, one other thing, this $7.3 million of indirect support, there is a canon of judicial ethics that required Justices Rochford and O'Brien, when they were considering the Caulkins motion for their disqualification, affirmatively to disclose any information they knew that Caulkins obviously did not know that Caulkins would consider relevant to their recusal. And what they concealed was a 400% increase in the sum of financial contribution from defendants or originating from defendants, including counsel in the very case that we were dealing with that wasn't disclosed. To me, I'm within 7 days of learning this information, and it's the classic Illinois story. Outrageous, stinks to high heaven, and another chapter of blatant disregard for the rule of law and the rights of citizens in this state. It is, we're raising it. We're going to bring it to the attention of the United States Supreme Court. But that's a change. That's a change since all of this has taken place. And Illinois has got to change the way it does business, because, if this is tolerated, there is no limit. Next time somebody wants to heavily finance a seat on the Illinois Supreme Court, you know what? They'll just look what we got by with here. So if we are able to do it once, let's continue to do it. So we'll continue to encroach upon common sense and the fundamental rudiments of due process time and again, so that we can achieve what is convenient to our political end. And that's unfortunate. So we stand here in this case saying there is something far more persuasive and important, or at least equally so, that leads our petition to the Illinois Supreme Court. And that's before we even get to the Second Amendment issues. But the Caperton challenge is, in and of itself, using the processes of government, if you will, to achieve a political end. And here, the political end, the context for all of their action, is stripping a fundamental constitutional right in the form of the Second Amendment. I mean, they're just not doing this so that they can favor a private litigant wanting to avoid a punitive damage judgment, like some of our precedent State Farm case and things that were thrown at us before the Supreme Court of Illinois. This is something far more pervasive, fundamental, and strikes at the heart of the very legitimacy of our institutions in this state.
We're talking with
That's
Jerry
the point we're
Stocks.
wanting to make.
Yeah, and we're talking with
Firmly
Jerry.
held and believed. And I don't really think that any commentator reflecting on the way business is done in Illinois truly questions whether we're accurate. And the press, the Chicago Tribune has criticized this most recent round of contributions last week. The Champaign News Gazette called the whole episode of the recently discovered non-disclosed independent expenditures to reflect sleaze and disrespect for the voters of Illinois. So we don't stand alone. And this case is taking one huge step here imminently on that front. I know this week that the state has to respond to the application of what I will call the Beavis plaintiffs seeking a stay of the assault weapons ban pending resolution of their case. And we plan to join, not necessarily join, but to file our own application, which is in preparation as we speak, seeking similar relief.
Talking with Jerry Stocks, he is the attorney for State Representative Dan Caulkins, who has his case in front of the U.S. Supreme Court, at least docketed. And just to take a look at this as we're following along here, again, you guys had this docketed on the 14th, and the state was to reply by the 14th of December. But on Friday, we're just clicking through here, the waiver of right to respond. It looks like they checked, I'm filing this waiver on behalf of respondents. I am a member of the Bar of the Supreme Court, filing a signed waiver, and the system will prompt you, ultimately saying that they do not intend to file a response. Isn't that, I know court precedent sometimes is if you got a plaintiff who shows up and the defendant doesn't, whenever the court gives, here's the time you have to do this. I mean, isn't judgment for the plaintiff? What could happen next here after you guys file an amendment, which is going to include the additional supplemental spending that you've uncovered, and that the other political ramifications behind this? But what do you see happening here? They take the case, they hear the case, or could they move a little bit more expeditiously? What kind of prognostication can you give us?
Well, predicting what a court of review will do as to whether they take a case or not. We present extreme facts in a very ugly set of circumstances that took place in Illinois. That can be both compelling, or it also can be, we may not want to wade into this mix. When we file our supplemental grounds for our petition, it is possible that the court will give Pritzker a second opportunity, at least to respond to the supplemental information. However, I don't think they will, at least insofar as the Caperton challenges and the supplemental material, because they have to not defend so much their conduct, they're defending and appearing to defend the conduct of the justices at the Illinois Supreme Court. The other thing is that the moment they respond to what we filed, it will trigger for those counsel and those parties the affirmative duty to disclose fully the nature and extent of their contributions, engagements, and support of these justices. So they are somewhat shackled because rules of professional conduct, once they respond, that response must be complete and not misleading. By standing silent, they can avoid the trigger of that duty. So I think in some respects that may inform part of their strategy. Another part of their strategy, I assume, since they know they have to respond this week to the Beavis petitions for injunctive relief, they may try to shoehorn some of the substantive components of the case related to the Second Amendment and feel that they need not respond to that in our case because it's going to gain audience at the next level. But that's supposition. As you know, on our Second Amendment view, we take a different slice of the debate than the Beavis plaintiffs. We start with a common proposition that the Second Amendment extends prima facie to arms commonly possessed for lawful purposes. And then Beavis is litigating, what is common and dangerous. And we in Caulkins said, we don't need to do that because once the standard is the Second Amendment extends prima facie to arms commonly possessed for lawful purposes, it becomes more statutory construction to us is that this ban continues to recognize for the grandfathered that these arms, assault weapons, are commonly possessed for lawful purposes and will continue to be so possessed for lawful purposes. Thus, the question, does the Second Amendment cover them or not, is answered. It's answered by the four corners of the statute. So now we get into, is there any basis to distinguish the grandfathered from the prohibited, the classification of persons, which in the very first pleading we did, we drew that distinction. Now, it was conflated by excluding prefatory language from our contentions in the trial court below, in the Illinois Supreme Court opinion. In other words, conscious editorializing and revision of what we actually had argued, that we had totally ignored the Second Amendment. Well, you were sitting in the courtroom. We didn't totally ignore the Second Amendment. We says it is the backdrop by which we have to ask ourselves, can we create a Second Amendment with one set of rules for the grandfather and a Second Amendment for under a separate interpretation for the prohibited, that classification of persons. And the only difference between them, they're all FOID card holders. So it means none of them have personal prohibitors. But the mere fortuity of date of acquisition of the weapon. Now, what the state responded with, which is one of the more profoundly oxymoronic contentions I've witnessed in 35 years of litigation, is that this reliance factor is that the grandfathered relied upon the Second Amendment to have their firearms. And for that reason, the Second Amendment does not apply to those that are prohibited from acquiring the firearms. It just is simply, all they're saying is that we've amended now the Second Amendment and given a sunset date to its application to the future. There is nothing, if we look at Second Amendment analysis, there is certainly no analogic history to separate persons on that ground. If we look at it from equal protection, whenever you have a criminal statute, which I think sometimes people gloss over, it is well established that a criminal statute cannot immunize one group of people from criminal prosecution and expose another group to criminal prosecution based upon the same conduct. And the conduct here is the possession of an assault weapon. And so it is so defies fundamental principles, basic notions. I'm talking the first 6 weeks of law school, constitutional law, you grasp these concepts. It is almost, you get by with it because it is so unbelievably simple that it is a violation of constitutional law, that you almost get by with it because it's difficult to conceive that state actors would not have a better method of trying to resolve these issues. If you wanted to take my firearms, I think I would have executed a different game plan, not one that's so obviously infirm. I think anybody that has followed the issue scratching their head saying, how do you get by with this? But I don't know, that's what we're fighting. And my one criticism of what's taking place in federal court is they got too wonky with the guns, and what is or is not military type or common dangerous, that which are all issues that, if not in this case, in some case will need to be conceivably litigated. But I think the four corners of this statute makes the invalidation of the Illinois Act far more simple and far more immediate. And so, and the other concern is that in the Beavis case, our view is not represented. The classification of the persons is not fully vetted. So between the two cases, my hope would be that neither side is left in the dark, that the cases would get on track and be considered at the high court together.
Jerry, I've got
But our Caperton challenge, if our Illinois Supreme Court opinion was vacated based on the denial of due process, which would be a valid, sound, and consistent with the Caperton precedent, that would restore the final judgment of the trial court. That final judgment is not precedent, but what it is res judicata and collateral estoppel that would bar the enforcement of the particular act across the state. The impact that a final judgment has. So
again, just to reiterate, and I'm running out of time here for my free version of Zoom, so I appreciate you taking the time with us. But if they do take the case and they find that these justices should have recused themselves, you're saying even though the justices were split, Rochford was against Caulkins, while O'Brien was on the dissenting side. Ultimately, the big takeaway is that it would revert the decision back to the circuit court's final judgment.
It does, because one, improper justice pollutes the entire panel. Two, if Rochford would fall, even if we want to get in a sense of materiality, which is not something that, Caperton's told us that's not how you do it. But even if you did, that would drop you to only 3 on affirmation and or on reversal. And under the Illinois Constitution, you have to have 4 to take any action. So each of those would have the legal impact of restoring the final judgment, because it would be the last valid act of the Illinois courts, affirming that final judgment that invalidated the statute against these parties who are the ones enforcing it. And that would be res judicata across the state.
Jerry Stocks, attorney for State Representative Dan Caulkins, greatly appreciate you taking the time with me and delving deep into this. And obviously, we'll be talking more as we anticipate seeing your next filing at the U.S. Supreme Court. All right? Be safe out there.
All right. Thank you.
All right, so that is Jerry Stocks, again, the attorney for State Representative Dan Caulkins, laying out in detail how he plans on filing yet another filing after Governor J.B. Pritzker said that he does not intend to file a response. But again, we've heard the governor in his discussions when asked about why he donated $1 million to 2 Supreme Court justice candidates. And here's just some of what he had to say, if you recall.
This is something that the right wing is trying to stir up. I know you've written about it. The fact of the matter is I supported candidates who are running all across the board. If you're suggesting that the fact that I gave money to, let's say, the Democratic Party or to the committees that supported candidates means that everybody who received any money has to recuse themselves from anything to do with the state of Illinois, that's ridiculous.
So again, Governor J.B. Pritzker says it's ridiculous to assume that money could possibly lead to a conflict of interest. Obviously, we'll be tracking that and so much more. Appreciate you guys tuning in with Bishop on Air. That was a long one.